Said it's 8:30 at least, so we shall go ahead and get started, even though we don't have a full complement of the committee. And you will notice, well, no, you won't notice. I guess it's just those of us on up here, chair, vice chair, and ranking member, have an agenda. It's red. So you can determine if it's red because this is February the 14th. I guess that's some kind of a holiday. I'm not real sure what it is. Or even more importantly, the Kansas City Chiefs are, again, world champions of the National Football League. And I've been paying attention to that since 1968. February 14th, I didn't start paying attention to that till I was a little older, like 12 maybe. But in any event, we shall get started with our agenda, and we have an item on the agenda, and that is a bill hearing for Senate Bill 389. So we shall open the hearing for Senate Bill 389. And first up, we will have an overview of the legislation from our reviser. So Reviser Lawrence, the floor is yours.
Thank you, Mr. Chairman, and good morning, committee. So Senate Bill 389 deals with the Farm Animal and Field Crop and Research Facilities Protection Act. Currently, that act prohibits persons from acquiring or exercising control over an animal facility without effective consent of the owner and with the intent to damage, recording, attempting to record, or trespassing to record on an animal facility property, again without effective consent of the owner and with the intent to damage, and trespassing on an animal facility without the effective consent of the owner and the intent to damage the enterprise. Several years ago, the state was sued by the Animal Legal Defense Fund over this statute, and they argued that the prohibitions I just mentioned violated the First Amendment's free speech clause, and the 10th Circuit Court of Appeals agreed, stating that those provisions include deception as a possible element and are viewpoint discriminatory because they only apply to persons who intend to damage the enterprise of an animal facility. The court affirmed the injunction against the state from enforcing those provisions. So Senate Bill 389 seeks to remove the unconstitutional intent parts of the act while still prohibiting entering or remaining on and knowingly making false statements to gain access to animal facilities and field crop production areas. You can see those changes in Section 2 of the bill. Additionally, the bill would clarify the penalties for any violations of the act, and Section 1 of the bill would make conforming changes to the definition section of the act. And the bill would take effect on July 1 upon publication in the statute book, and I would be happy to answer any questions.
I notice under the definition of animal facility, it includes a vehicle, and there are several things included there. I also noticed that a research facility includes an elementary school, secondary school. And then on page 3, I'm looking at line 9. I'm not even sure what section and paragraph, doesn't matter. It says without the consent of the owner. So what would be or who would be the owner or who could provide consent for being on a facility such as an elementary school or secondary school? Would that be the administration to your interpretation?
So the act does define the term owner, and it says it is a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property other than the actor. And I believe with elementary and secondary schools, we would be talking about the boards of education over that school district who runs those schools.
Okay. Questions, committee of our reviser. Senator Reichman.
Thank you, Mr. Chairman. And I guess the whole bill and this whole problem or whatever we have here, it doesn't make sense to me too much. Seems like to me, and just face value, if you're going on somebody's property, personal property, you should let that person know or, get consent. And so I have problems with the court when they ruled on that. They said concern speech because they include deception as a possible element Can you just kind of help me understand why we have to come up with a bill like this? I'm just baffled. Thank you.
And that may be a question more for our conferees as to why.
Okay, sure,
But if you wish to answer, you're welcome to do that, Senator Advisor.
I'm always happy to defer the why to someone else. But I will say that the court did find this violated. There are some elements of this statute did violate the First Amendment, and so this bill is removing those particular elements while still leaving it a crime in some instances to enter and remain on these properties.
Seeing no additional questions, we shall move to conferees, and we have a proponent this morning, Mrs. Jackie Garagiola, who is the Associate Counsel for the Kansas Livestock Association. Mrs. Garagiola, that's a long name that kind of stumbles over a little bit. So we'll try our best.
That's perfect. You did a great job. So thank you, Mr. Chairman and committee members, for allowing me to be here today. I'm here to testify in strong support of SB 389, particularly because we were the end of the action to amend this bill in order to maintain these protections for our livestock facilities as well as the crop research protection areas. As was said, I'm Jackie Garagiola, Associate Counsel with the Kansas Livestock Association and representing our roughly 5,700 members across the state. We believe that if passed, SB 389 would ensure protection against trespass and entry through knowingly fraudulent statements on employment applications to protect animal facilities and field crop production areas. I'd like to point out specific KLA policy that led us to take this action. We have specific policy that states that the association supports initiatives concerning acts against livestock industry to not only strengthen penalties for anyone involved in illegal biosecurity activities affecting the agricultural industry, but also to allow producers to secure their facilities and operations at all times. We believe that the impact of the 10th Circuit case on this act has taken that ability away. It primarily struck provisions of the act that apply to animal facilities, and we wanted to make sure to take some initiative and to seek to amend that act so that we didn't lose those protections, but we don't want to be in violation of the First Amendment and violate constitutional rights. So, as the revisor stated, it was found unconstitutional in part back in 2022 by the 10th Circuit. At the time, the state did appeal that to the U.S. Supreme Court. However, they were denied cert, and so we are left with this 10th Circuit decision, and that is controlling in Kansas. So our only available remedy was to come back and to modify the act to eliminate those provisions, given that roadmap that they gave us through the court case, and to take out provisions of it that were found unconstitutional. So I'm going to dive a little bit into the court case. I apologize for any legalese going forward. And I'm also going to refer to it to the act because Tamara did a great job of saying the full name of that act, but I stumble over it every time. So going forward, I'll just call it the act. So the act regulated speech as opposed to merely conduct. That was the very first issue the court had. The issue that they had with it was the term effective consent, and so we have removed that language from all of the provisions of this act and strictly taken it to consent. And then the other thing that regulated speech as opposed to conduct was all the recording provisions that you heard about, things like photography and other methods of recording. They said that was directly to speech, and so we have removed that provision as well in order to comply. The main issue that the court had with this act is that it forbid certain speech made with the intent to damage the enterprise conducted at the animal facility. The court specifically said government discrimination among viewpoints or the regulation of speech based on the specific motivating ideology or the opinion or perspective of the speaker is a more blatant and egregious form of content discrimination. And because the act prohibits only acts of those intending to harm the facility and not those who might seek to help the facility or do good things for the facility, whatever that might be, that would be viewpoint discriminatory. So they also gave us a little nugget that we took as kind of our roadmap for this bill, which states that while it may be permissible to punish all entry onto private property by deception, the act becomes impermissibly viewpoint discriminatory by choosing to punish only entry by deception with the intent to damage the facility. So this indicates to us that by simply disallowing the entry through deceit or without consent, that that's okay as long as it doesn't have the intent piece that we had talked about. So this bill has stricken the language intent to damage and has created a simple prohibition on trespass or fraudulent employment application. And so that's the main parts of the bill that I wanted to discuss. There is one other thing that I really want to point out because it's been a big deal for our livestock facilities, and that's that we have received a number of calls of low-flying drones over their facilities. This isn't just a security issue for us, it's really a safety issue, especially for our employees. I think that the individuals that did over the particular facility I'm thinking of were thinking that maybe no one would be out there at 4 a.m., but our workers are out there at 4 a.m., and when the cattle are disturbed or spooked, it does become a problem of safety, and so we wanted to address that here as well. So we actually added in a new definition of trespass to include the airspace above these facilities or production areas for aircraft, and it is tied to the federal regulations. So it prevents the space up to what the federal regulation says is safe flying altitude, which would be 500 feet, and then it goes down as you get closer to airports to account for, obviously, there's going to be something under that altitude a little bit closer to airports, which is fine. But we didn't want to conflict with any state or federal laws, so we tied that to the federal regulation just to be safe. I think that gives a pretty good overview of the amendments that we made to this language, but I'm happy to answer any questions, and this is just critically important to us. We've worked on this for about 2 years now since the 10th Circuit ruling came out, and we've involved other industry partners who you'll see written testimony from, and at that point, I'd be happy to stand for questions.
Committee questions of Mrs. Garagiola. So we'll let you stand at this time for questions since you are the lead proponent and the only one scheduled to testify in person. Senator
Perfect.
Straub.
Thank you, Mr. Chair, and thank you, Ms. Garagiola, for bringing this to us today. It also kind of triggered my memory of the cotton boll weevil bill that we had last year, and maybe you can shed a little light on, in that bill, it says authority for the board's designee to enter private property too, and in that bill, all they have to do is attempt to contact the private property owner. They do not have to have consent. So that may be, I mean, I'm assuming that the court ruled that you must have the private property owner's consent.
Consent is fine. It's the effective consent piece, and it was the intent to harm language that they found unconstitutional. They said it's fine. Essentially, it's fine to, giving us a little bit of a roadmap, to ban entry as long as it's not taking into point people's perspectives when you're doing so. But it's fine to ask for that consent piece.
Yes, I think we need to go back and amend that statute also to make sure that we have the private property owner's consent. Not effective, not expressed, but absolute consent. Yeah, thank you.
Thank you.
Additional questions, committee? Senator Francisco.
Thank you, Mr. Chair, and thank you for being here. I appreciate what I think is a very good explanation. We do have some written-only testimony from the Kansas Sierra Club by Zach Pastora, and I would like to make sure that you get a copy of this. I think you've already answered one question, which he was concerned about the aircraft flights, and thank you for answering that. So his other concern was about traffic accidents. Had you seen this before today, or?
I had not. I looked at it right before committee, so I apologize. I was not prepared for that one. So that piece of it, that definition existed in the original statute, and it wasn't contemplated in the 10th Circuit case. So I will say that would be something that I don't have a ton of insight to, is why that definition was written the way it was at the beginning. And so I can't speak to the intent of that part because we did not amend that section. And so I haven't had a chance to really address that issue, but I'd be happy to take a closer look at it.
So I would appreciate that, and if there is a way to make sure that that isn't covered, because I'm sure that that's not your intent.
Accidents as opposed to intentional.
Right.
Yes.
We do have Senator Ware online, and she's wanting to ask a question. Senator Ware.
Thank you, Mr. Chair. I guess I'd like to hear a little bit more of the backstory. Is this primarily an issue that's come up as of drones being so prevalent, or is there more that's bringing this whole issue up?
So this is not singular to Kansas. It's something there are laws in a number of other states, and I believe a number of them were initially enacted, and I think actually this might address a little bit of why vehicles were included in the definition, is that there were individuals in protest setting fires to facility trucks and other situations where there was being damage caused to facilities, not just the actual facility, but also the vehicles as well. So I can assume that that was some of the original intent. I'm not fully aware of, because this is a statute that's been around for a significant amount of time. It was amended even as, not that recently to the post 9/11 tax. It was amended in order to address some biosecurity concerns. And so it has been around a long time for what I would consider an ongoing issue. What we have seen most recently has certainly been the drones problem of low-flying drones over facilities that have distressed cattle. And it's just getting recently brought up again because of the 10th Circuit Court case. So.
Senator Ware, is that the extent of your question for this time?
I think so. Thank you.
All right. Committee, additional questions. I was curious, Mrs. Garagiola, regarding the penalties at the bottom of page 3 and into page 4, the severity level. Do you feel these are strong enough penalties? Or, because I see that it's a non-person misdemeanor, depending on what exactly they do, but it can enter into a non-person felony, severity level 9 and then severity level 7. So I guess, again, my point is I want to make certain that if we pass this legislation, that the consequences for violating state law are sufficient.
Definitely. So I will say that as with regards to the first section of violations that work their way into a felony, depending on the cost of the damage, that was in the original statute. The only modification that happened there was to match them to the appropriate section. The second one has been modified slightly, and that was because we added the new definition of trespass, new section for trespass, and in that there were some concerns that because we have to eliminate the intent piece, the intent to destroy, from the language, that intent is a part of the felony requirements. Now, I say this as not a criminal attorney, so I say everything with a bit of a grain of salt because while I'm an attorney, that is not my area of expertise. We were given that guidance by someone who does have that type of expertise, that would be better suited as a misdemeanor. And then the final violation, that has not changed from the original statute. And we are comfortable with that level. I think it seeks to deter individuals really from entering on these facilities and causing damage or lying on an employment application. That's really the intent of this bill, is to create that deterrence. And I think we see these as sufficient.
Okay, thank you. Senator Reichman.
Thank you very much, Mr. Chairman. Thank you for coming and bringing forth this bill. I wish you'd give a little bit of a history of maybe what's going on not only in the state of Kansas, maybe other states, why you have such a concern about what's going on. Thank you.
So I can speak a little bit to the original language because there were provisions in there that talked about recording and photography. We are an industry and that is one maybe not so understood by other parts of the country, and what can be a very normal practice and very humane practice may not be seen so. And so I think some of this was initially intended to prohibit the spreading of false information. However, that's specifically what got us into trouble with the freedom of speech constitutional provisions and why that's been taken out. I think that was some of the original intent. Recently, like I said, I can only point to the drone piece of things. I don't know of members that have reached out to us in the real recent future about people actively coming on the facility and destroying property. But I know that has occurred in other states, specific example being the setting fire to a truck in California. That was something that happened. And I know it has happened in other areas. And we have heard reports in other states of individuals lying on employment applications to gain access and then to conduct those activities. And that's what this is really trying to get at here, is to make sure we still have those protections, but we don't want to get into all of the constitutional violations because we want this act to work. We don't want it to end up back in court and not have those protections again. That's probably about the background that I can provide because I don't have any more specific instances in Kansas, but what's to say it doesn't end up that way here if we don't have these types of deterrences and protections.
Seeing no additional questions, I appreciate you appearing before the committee and answering questions on behalf of the legislation committee. I will also direct your attention to the fact that we have written proponent testimony from Randy Stuckey, and he is a joint proponent for the Kansas Grain and Feed, Kansas Agribusiness Retailers Association, and Renew Kansas Biofuels Association. So that's a joint for 3 different organizations. We also do have written testimony from the President, CEO of the Kansas Pork Association, and from Kansas Farm Bureau. So that is the extent of our proponents. And as far as opponent, we have written only testimony from the Kansas Sierra Club, Kansas chapter of the Sierra Club. And so I would urge you to take a look at all of that testimony. If you have questions of anything that is written in that testimony, reach out to the various individuals, ask your question of them. We do not have any neutral testimony, so therefore we will close the hearing on Senate Bill 389. And I have nothing else on the agenda committee for this committee meeting. So with that, we are adjourned.